Welcome to Gwungmijana's Legal Relief channel on Law of Trust series. Today's video is continuation of the discussion on classification of trusts. Fortunately, this will be the last video on the discussion of classification of trusts, specifically constructive trust, which is the last class of trusts I discussed in the last video. So today I shall end the discussion of classification of trusts and the discussion on constructive trusts. In the last video I discussed one of the areas of application of constructive trusts. Constructive trust is the trusts imposed. It's a trust relationship that is imposed on the parties by law, irrespective of their intention. So there are some circumstances where the law will actually impose constructive trusts. And these circumstances are regarded as the areas of application of constructive trusts. The first area, as I mentioned in the last video, is trustees and other fiduciaries, unauthorized profits by trustees and other fiduciaries. Unauthorized profit by trustee and other fiduciaries. So, for a better understanding, if you have not seen the other videos, you need to see it for a grounded understanding and a logical understanding. Now let's look at other areas of application of constructive trusts. Another area of application or circumstance where the law will impose constructive trust on the parties is stranger receiving or intermeddling with trust property. Yes, stranger receiving or intermeddling with trust property. So there's another circumstance where constructive trust will be imposed on the parties, and in this case it is on a stranger. Constructive trust will be imposed on a stranger where he receives or intermeddles with a trust property. Now let's look at examples of cases where this trust too can be imposed. So under this, where a stranger receive or intermeddle, we still have some example of cases or some aids or some circumstance where it can be imposed. First, who is a stranger? In this case, a stranger is a person who is neither the trustee nor the beneficiaries, not among the beneficiaries, not also a trustee. It's a person who is not entitled to the trusts. Is not entitled, does not have any right to the trusts. And the law is that where such person, a third party, receives or intermeddles two things with a trust property, then constructive trust will be imposed on such a stranger, so that he cannot take the benefits of that property, but he will hold it as a constructive trustee for the benefit of the beneficiaries or the person entitled to the property. So the first circumstance under this aid is, it was laid down in the case of Mara versus Brown. Mara versus Brown. The court laid down one principle regarding the liability of a stranger in relation to a trust property. So the court stated that where a stranger or where a person without the authority of the trust of the trustee intermeddles or acted as a trustee, then he thereby make himself a trustee of his own wrong, known as a trustee disuntot. A trustee disuntot. So if a stranger, one, intermeddles with trust property without the authority of the trustee or trustees, or he acted in the office, which is characteristics of a trustee, that's acted as a trustee without the authority of the actual trustee, then he had made himself a trustee of his own wrong. He has by that wrongdoing made himself a trustee, and the trust in this case is trustee disuntot, which is also known as constructive trusts. If you have watched carefully and also listened carefully, in the previous video I identified some of the some other names for constructive trust, and one of the names that the court listed in the case of Mosu versus Mbekwe is that a constructive trust is also referred to as trustee disuntot. So another name for a trustee disuntot is a constructive trustee. So a constructive trustee is also a trustee disuntot. So there's the rule as the court stated in Mara versus Brown, that as a stranger, if one, you receive, you intermeddle. You know, some people are very good at intermeddling in something, in affairs that does not concern them. You can better refer them as a meddlesome interloper. You know, officious interloper. So they are very good at that. Something that does not concern them, but you will be seeing a busybody as if they are the right person to act. Just like sometimes to be in school, you see some lecturers, they want to take over the class of other lecturer, while other lecturer is in class, another lecturer is in class, they want to take over. You see them be acting. Oh, you there? You see, there's a busybody. Once another lecturer is in class, you should be the one that will be in charge, not another lecturer coming to say, you there, you are in class, the students are making noise, you allow the student to be making noise, you are in class and you allow that student to remove his jacket. So those are very some interloper. So if it is in respect to a trust property and a person acted without authority, acted as a trustee, or intermeddles, deals with the property without authority, then it will be treated as, it is not that if thereby by doing so he make himself a trustee, but in this case a trustee of his own wrong, which is a trustee disuntot. Trustee disuntot. So there's one instance under this heading. Another instance under this heading is where a stranger receive a trust property with the notice. The notice could be actual or constructive notice. So where a stranger receives a trust property with actual or constructive notice that the property is a trust property, will also be treated as a constructive trustee of that property. So if a stranger, a third party, a person knowingly receive a property which is a trust property and he has notice, he actually has a notice that it is a trust property. So another example under that heading is where a stranger receive a trust property and knowingly that the trust property was transferred to him in breach of a trust. That is, if a stranger receives a trust property with the knowledge that the transfer of the property to him was done in breach of a trust, an existing trust, then he will also be a constructive trustee of that property to the beneficiary. So the first aid is where a stranger intermeddles or acted as trustee, who becomes a trustee of his own wrong. Now, where he receive a property with the knowledge that the property was transferred to him in breach of trusts, and the knowledge, his knowledge of the trust could be actual knowledge, knowledge that he has personally, or constructive notice, actual notice rather, or constructive notice. So if you receive the property with actual notice or constructive notice that it was transferred to him in breach of trusts, so the notice could be actual or constructive. That's the notice that comes to him personally, and the one that is, you see, anything constructive is usually imposed, it's usually done by law. So constructive notice now is any notice that is affixed to a person by law, where the person failed to take notice as a result of a lack of due diligence on his part. So if he was supposed to take notice, but because he felt it was not a diligence, then the law will affix him with constructive notice. Just like the same way will also be the law will also impose constructive trusts on him. So you can see, so there's another instance under that aid. Another instance is where he received the trust property without knowledge of the trust, but subsequently have notice of the trust, and deals with it in a manner inconsistent with the trust. It will also be declared a constructive trustee. So there's three circumstances. Another circumstance is, in this circumstance, is where it does not actually receive the trust property. So if a stranger does not actually receive the trust property but knowingly assists a fraudulent dealing with the trust property. So if there's a fraudulent dealing with the trust property, but a stranger assists in the fraudulent dealing, assist those dealing fraudulently with the trust property, then it will also be a constructive trustee of that property if he knowingly assists. So it's just like somebody that is aiding a wrong. For instance, in criminal law, aiding an offense. In fact, breach of trust is an offense. So where a stranger, although he did not actually receive the property, but knowingly assists the trustee. So if he knowingly assists the trustee to deal fraudulently with the trust property. So those are the instances under this aid. And the aid is stranger receiving or intermeddling. Two things: it either receives or interferes with the deal with the trust property without authority. There's intermeddling. So there's another area of application of constructive trusts. However, before we proceed to the next application, take note that there is exception as to the stranger receiving a trust property. So if he received the trust property, if the trust property is transferred to him and he does not have knowledge of the trust, he does not have notice of the trust, that is, if he is a bona fide or a bona fide purchaser for value without notice of the trust, then it cannot be held as a constructive trustee, because in that case is a bona fide purchaser. He received the property in good faith without a fraudulent dealing, without a collusion with the trustees. So there's the exception to this heading. Let's go to the next area of application of constructive trusts. The next area of application of constructive trust is vendor of land as constructive trustee. Vendor of land as constructive trustee. So in a land transaction, you have the vendor, there's the seller, and the purchaser or the transferee. Now, there are instances where the law will impose constructive trust on a vendor, on a person selling a land. And what is the instance? Once there is a binding and enforceable contract for the sale of land, once there is a valid contract for the sale of land, the vendor becomes a constructive trustee of the land for the purchaser. So the point is that once there is a contract by the vendor, the person say who owns the land that want to sell it, and the person buying it, once they have entered into a contract that is binding and can be enforceable, a specifically enforceable contract for the sale of land, immediately the contract is concluded, the vendor becomes a constructive trustee for the sale, for the purchaser. This because once the contract is entered into, the purchaser acquires an equitable title in the property. So the purchaser has an interest in the property. Once the contract for the sale of land has entered into, the purchaser has equitable interests in the property. And you know a trust is an equitable right. Therefore, the seller or vendor becomes a trustee. It will be bound by law to hold the land on trust as a constructive trustee for the purchaser. So their rights will change. The rights of the purchaser will be the right in the land, while the vendor, his right will be the right to the purchase money, to the purchase money. So there's another area of constructive trusts. The implication is that the rights of the parties has changed. So in this case, if maybe the land and something happened to it, happened to the estate, the property, for instance, there's a building on the land to be sold, and something happened after they have entered into the contract. Because of this, it is actually the purchaser that will bear the loss, any risk that is occasioned or that arises after the contract has been entered into. Despite that, the vendor is still in possession of the land. However, the vendor can be in possession, but once can be in possession until the transaction is completed and the land is conveyed to the purchaser. So, but their rights, the implication is that their rights will be determined accordingly. Also, another implication is that if the vendor dies before the completion of the contract, before the land was actually conveyed by maybe a deed of assignment or deed of conveyance to the purchaser, the estate of the vendor will still be treated as constructive trustee to the purchaser. They will hold the land on constructive trusts to the purchaser. And that was what the court held in the case of Lysot versus Edward. In fact, it was in that case that the court stated this principle. So in Lysot versus Edward, Judge Jessel Mester stated the principle of law that once the contract has been entered into, then there is the right of the party has changed. And what happened in Lysot versus Edward? In that case, there was a contract for the sale of a farm, for the sale of a property, and the property was a farm, but the vendor died before it was completed. So before the contract was completed, before the land was actually conveyed to the purchaser, the vendor, the seller died. Then under his will, the land passed to a trustee. Under his will, he has already, given the land to a trustee to hold on trusts for someone else. But the court held that the trustee was to hold the land on trust for the purchaser. That the land is to be held. The land was to be held on trust for the purchaser. So it was held that the trustee was a constructive trustee to the purchaser. So let's hear an example case where this trust, this principle was applied, that once there's a contract, so irrespective that the vendor is no longer alive, you cannot complain, the estate cannot complain, the land is already being held on constructive trusts to the purchaser. And this is also founded, this principle is founded on the Latin maxim, equity consider as done or regard as done that which ought to be done. So that's why once the parties enters into the contract, a binding and enforceable contract, then equity will say, oh, that's already in equity. It is considered as if it is done. And the contract must be one that is specifically, that is valid and is specifically enforceable, so that the purchaser can bring an action for specific performance of the contract. Now, the court stated this principle of constructive trust in the case of Ibekwe versus Nwosu Supra. The court lucidly stated this principle of constructive trust as follows. In that case, Supra, the court stated thus: the doctrine of constructive trust is that the moment, underline the moment, a party has a valid contract for sale, the vendor becomes in equity a trustee for the purchaser of the estate sold, and the beneficial ownership passes to the purchaser. The vendor having a right to the purchase money and a right to retain possession of the estate until the purchase money is paid. If anything, this is what I stated before. If anything happens to the estates between the time of the sale and the time of completion of the purchase, the risk of the time of the purchase, it is at the risk of the purchaser. Ellipsis. So look at what the court stated, that it is at the risk of the purchaser if anything happened between the time of sale and completion of the contract. So you can see what the court said, that the moment a party has a valid contract, once you have a valid contract for sale, the vendor becomes in equity. In equity, the vendor is treated as a trustee for the purchaser of the estate sold, and at that point the beneficial ownership passes to the purchaser. That's why it will be the one to bear the risk if anything happens. And the court made it clear that the vendor have the right to the purchase money and the right to retain possession. So the vendor will still retain possession until the purchase money is paid and the property is actually conveyed to the purchaser. So that's one is another area of application of constructive trust, and it is vendor as constructive trustee. So there is a circumstance, one main circumstance where a vendor can be treated as a constructive trustee once there is a contract for the sale of land. Let's go to another heading. Another heading is mortgagee and mortgagor as constructive trustee. So the principle of or doctrine of constructive trust is still applicable to the transaction between a mortgagee and a mortgagor. You know, a mortgage is simply the use of land as a security for a loan. So once you use your land to secure as security for a loan, then there's essentially mortgage. So in a mortgage, we have a mortgagor and a mortgagee. The mortgagor is the person who uses land to secure a loan. That's the borrower. While the mortgagee is the person that advances the money. That's the lender. And more often than not, it is usually a bank. That's the mortgagee. So in the relationship between them, there are circumstances where the law will treat the mortgagor as a trustee, and where the law will also treat the mortgagee as a trustee. So there are such a circumstance. Now let's look at an example of such a circumstance as with respect to the relationship between a mortgagee and a mortgagor. So one of the instances where the law will impose constructive trusts in a relationship between a mortgagee and a mortgagor is one. A mortgagee who has exercised his power of sale is a constructive trustee for the mortgagor of any surplus which remains after the principal, interest, and costs due to the mortgagee have been deducted. So this heading now is that a mortgagee, that the lender now, one of the rights of the lender, the mortgagee, is one of the right or its remedies if the mortgagor refuse to pay the money, refuse to repay it to fulfill his obligation. One of his rights is to sell the property that was used as security. He has the right of sale, the power of sale. So the law is saying that where he exercises this power of sale, it will become a constructive trustee for any surplus that remain after settling himself and settling every other encumbrances, every other things to be settled. Any money that remains after settling his own money, that is the principal money, the money he borrowed the mortgagor, and the interest, if there's any interest after settling the interest and the any other encumbrance, then any surplus, any money that remains after settling the main thing, he will hold that money as a constructive trustee to the mortgagor, meaning that he cannot deal with such a money the way he likes. The essence of trust is to make somebody accountable. Once the law declare you as a trustee, any property with respect to which the law declare you to be a trustee, you will account. You are bound to account to the beneficiary, and you're also bound to account to transfer the property to the beneficiary. So he cannot, after he has settled his principal, the interest, and every other amount that is due to the mortgagee, every amount that is due to him have been deducted. After deducting everything, the surplus, the remaining one, is to be held on trust for the mortgagor. You cannot just come and take everything simply because you have a mortgage. You have exercised your rights and you have taken everything that is due to you. So the remaining one, you are to hold on trust to as a constructive trustee for the mortgagor. So there's one circumstance. Another circumstance is a mortgagor, a mortgagee who enters into possession of land is a constructive trustee for the mortgagor of all rents and profits accruing from the property. So this is another circumstance. Still, this one now is still imposed on the mortgagee. The first one is where the mortgagee exercises his power of sale. It's a constructive trustee. Oh, I recall there is also a statutory provision for the first heading. That's where the mortgagee exercises his power of sale. There's statutory backup or provision of vituperations on that. It is provided by statutes, and there's section 21 Conveyancing Act and section 127 Property and Conveyancing Law of Western Region is the statutes that also provide for these trusts. So this trust is also provided by a statute, a circumstance where the mortgagee will be a constructive trustee. So those are the provisions. So the second one now is saying where a mortgagee enters into a possession of the mortgage property of the land, that a mortgagee who enters into possession of the land is a constructive trustee for the mortgagor of all, is a constructive trustee of all. These are the things for which is a constructive trustee. 1, rents. 2, profits. So all rents and profits accruing from the property. Another right of a mortgagee where the mortgagor failed to pay the money is to take possession of the property. So if the mortgagor fails to pay the money borrowed at the relevant time, at the due dates, at the agreed dates, one of the rights of the mortgagee is to take possession, to take over that property by appointing a receiver to manage that property. However, whereas it may be attractive to the mortgagee, in fact, it is not usually attractive to the mortgagee because of this principle of constructive trust, because the law requires the mortgagee to account for all rents and profits accruing from that property. That's why it is not always desirable by the mortgagee to exercise this right of taking possession, and they are to account the account that the mortgagee is expected to give in this regard is to be a reasonable account of rent and profits. Just like when the mortgagee too is exercising his power of sale, he must not sell the property at a very low price or undervalue. He must sell it for a reasonable price. It must sell it for a reasonable price. Otherwise, it will also make itself liable. So, in exercising of his power of sale, a mortgagee is a constructive trustee. Also, in entering into possession of the land mortgage, if he decided to take possession, it will also be a constructive trustee for any rents and profit. It will account to the mortgagor. Then another instance of constructive trust between a mortgagee and a mortgagor is where an equitable mortgage is created by deposit of title deeds. The mortgagor is a constructive trustee of the legal estate for the mortgagee. So this the two instances mentioned above now is the mortgagee. The mortgagee now is the mortgagor. So where there is an equitable mortgage, equitable mortgage is where the land is not actually transferred to the from the mortgagor to the mortgagee, but where there's an equitable mortgage, where equitable mortgage is created by the order of title deeds, the mortgagor is a constructive trustee of the legal estate for the mortgagee. So if the mortgagor did not actually transfer his land to the mortgagee but used his title deed, his title documents for that mortgage as the security, in that case it is an equitable mortgage, and the law is that in that case too the mortgagor is also a constructive trustee of that property to the mortgagee, because by depositing his title deed is an evidence of an agreement to enter into a legal mortgage, and the legal mortgage can be enforced by specific performance. So those are the three circumstances where constructive trust will be imposed on the relationship between a mortgagor and the mortgagee. Finally, let's look at the last heading of application of constructive trusts. The last heading or area of application is where property is acquired by fraud. Where property is acquired by fraud, then the person so acquiring the property will be a constructive trustee of the property so acquired. So if a person acquires a property, obtain a property in consequence as a result of fraudulent acts, as a result of fraud, equity will not agree for the person. It will not work. It will be in most circumstances, the person will be treated as a constructive trustee of that property to the person entitled to it. So another area of application is acquisition of property by fraud. Acquisition of property by fraud. So where a person has acquired property in consequence of fraud on another, it may be compelled to hold it as constructive trustee. So if you acquire a property by a fraudulent act, then the law can compel you to hold the property for the owner or the person entitled. You will be compelled to hold the property as a constructive trustee. One illustrative case in this regard is in respect of secret trusts. Is in respect of secret trusts. So there's a secret trust where the beneficiary is not disclosed. So a person may decide not to disclose who the beneficiary is, but will transfer the property to a person to actually hold it on trust for an undisclosed beneficiary or a secret beneficiary. So this principle has been applied in cases of secret trust. So if a person promise the testator that he will hold a certain property for the benefit of another person, and as a result the person actually refused to make a will in that regard, to include that in his will, then it will be treated, the person who deceived, who promised, or who made the testator not to include that in his will actually be treated as a constructive trustee of that property, because he promised, in fact he deceived the testator not to make a will and promised to actually hold it on trust for the person, for the beneficiary, but he refused to do so. Instead decided to take the property for himself. In that case, the law, because there's acquiring a property by fraud, so there's one example of cases where it is applied. And the relevant case there is the case of McCormick versus Grogan. McCormick versus Grogan. So in McCormick versus Grogan, the court by Lord Hartley LC stated the law thus, that where a person promises a testator that he will dispose of his property, and there was therefore no need for a will, trust, and the person who made the promise keep the property for himself, the court of equity will intervene on the ground of fraud by the person in inducing the testator to die intestate. So if a person induced the testator to die intestate based on the fact that he promised the testator to hold the property, certain property for a person, and by so promising, the testator felt that, or even convinced the testator, no, there's no need to make a will. Don't worry, I will hold the property in trust for him. Don't bother about will. Don't bother about creating a trust. However, the person, because there's no any documents now evidencing the transaction, now decide to keep it for himself. Equity will intervene on the ground of trusts. Equity will intervene on the ground of fraud. Rather, equity will intervene on the ground of fraud, and the person will hold the property as a constructive trustee to the benefit of the person actually entitled. That's the principle enunciated in the case of McCormick versus Grogan by Atley LC. This brings us to the end of our discussion on classification of trusts. Classification of trusts and the general aspects of the introduction of trusts. The next video which shall come on trusts will be on the appointment duties, breach of trusts, and the rest. But for the general introductory aspect, which is the meaning, nature, and classification, we shall end here. There are some things under the general introductory aspect which I may not discuss, but if you have questions on them, you can always send on the comment section, like the Cypress doctrine and trust and other legal relationship. I may not be able to discuss, otherwise I will remain on trust without making video on other areas. So if you have questions, you can always send on the comment section. And don't forget to subscribe if you are not, and also like, share, and comment. Thank you.